There are some jurisdictional and preliminary considerations in child support cases. Under the Uniform Interstate Family Support Act, there can only be one controlling order at any time, even when people have moved from state to state or are located in different states at the time of the establishment of the order. These matters can be complex depending on who moved where in relation to orders determining custody and visitation were entered. These are things best gone over in detail in a consultation. As with custody cases, child support is never really finished during the minority of the child. It can be amended at any time, depending on changed circumstances, usually financial circumstances. Again, however, there's a certain amount of inertia of decisions, so most judges don't allow orders to be altered unilaterally or very often. There is a statute indicating that a child support order should be reviewed and modified at least every 3 years. In Nevada, child support is determined in accordance with the percentage of income, starting with 18% for a single child and going on 25, 29, 31, as there are more and more children who are in the household of the receiving parent. There's a presumptive minimum payment for child support of $100 per month per child, and there's a presumptive maximum child support in a series of bracketed ranges, so that parents making a little bit more than $50,000 per year pay a maximum of about $550, which is adjusted with inflation, and stepping up with the income of the non-custodial parent. So a parent making about $180,000 a year pays an inflation-adjusted sum closer to $900 per month. The chart of current presumptive maximums and the child support chart showing the percentage that corresponds to income ranges are both set out on this page. Courts can exceed the maximum or dip below the minimum based on written findings of grounds to do so. Additionally, there are deviation factors built into the statute for certain listed factors, the most commonly used of which are the cost of childcare, special educational needs of the child, and the legal responsibility of the parents for the support of others. The rules are a little bit different in split custody cases or 50-50 shared custody cases. Under a pair of cases called Wright v. Osborne and Wesley v. Foster, the court basically does an offset so that the child support is figured of each parent to each parent and then subtracted one from the other, with whoever owes the bigger amount ending up owing that amount minus the amount the other parent would be paying to the 50-50 shared custodian. If the parents have vastly different economic resources and incomes, then there might be no difference between a 50-50 custody case and a full custody case to the poorer person in the event of a split custody decision. But these are rather fact-intensive and, again, should be gone over in detail with an attorney. Medical expenses, usually including the cost of insurance and any unreimbursed medical expenses, are split on top of the child support. They are not included within it. The duration of child support in the state of Nevada goes until a child reaches 18 years of age if no longer enrolled in high school, or if the child is still enrolled in high school when the child reaches 19 years of age. Child support can also be extended if the child is handicapped under the definition in the statute, but there is no provision in Nevada law for ordering anyone to pay for college expenses. If the parties agree to it, that can be enforced. In the absence of it, courts are not allowed to order it. In any contested case, both parties will be called upon to file affidavits of financial condition, even though, in Nevada, child support is determined in accordance with the income of the non-custodial parent. Essentially, there is no statute of limitations for any child support order entered after 1981, and interest and penalties accrue as to any amounts of child support that are not paid. Penalties page on this website for further information in that regard.